I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help. You just got served. A process server knocked on your door, handed you a stack of papers, and walked away. Your hands are shaking. Your stomach dropped. And right now you're thinking, what do I do? Here's what most people do. Absolutely nothing. They panic. They freeze. They stuff those papers in a drawer and hope the problem disappears. And that one decision, doing nothing, will cost them thousands of dollars. But in the next few minutes, I'm going to show you exactly what to do the moment you get sued by a debt collector. One document, one move, and it changes everything. Stay with me, because at the end of this video, I'm going to give you the single most powerful tool to stop a debt lawsuit in its tracks, even if you've never set foot in a courtroom in your life. Who this is for: if you've been served with a debt collection lawsuit, whether it's from a credit card company, a medical debt, a personal loan, or one of those junk debt buyers you've never even heard of, this video is for you. I'm going to walk you through what happens when you do nothing, what happens when you take action, and exactly how to take that action today. The problem, the silent epidemic. Let's start with a number that should shock you. Over 95% of debt collection lawsuits end in a default judgment against the consumer. That means more than 9 out of 10 people who get sued by a debt collector simply never respond. And here's what that silence costs them. When you don't respond, the court doesn't wait. The debt collector's attorney files what's called a motion for default judgment. The judge reviews it, and without ever hearing your side, stamps it approved. You now owe everything they asked for. The original debt, interest, court costs, attorney fees. A debt that started at $1,200 can legally balloon into $8,000 or $10,000 by the time interest and fees are piled on. And that judgment doesn't just sit on paper. They can garnish your wages, freeze your bank account, and put a lien on your property. And here's the part that makes this even more painful. Most people who get sued by debt collectors actually have valid defenses. The debt may be past the statute of limitation. The collector may not be able to prove they actually own the debt. The amount claimed may be wrong. But none of that matters if you never show up. Silence is a forfeit. And the system is designed to count on yours. The solution: file a written answer. So what do? You file a written answer with the court. That's it. That's the move. Not a phone call to the debt collector. Not a payment arrangement over the phone. Not a panicked email to the law firm. A formal, written answer filed with the court where the lawsuit was filed. Here's what that does. It tells the court you exist, you're aware of the lawsuit, and you are contesting it. The case cannot proceed to default judgment once your answer is on file. The debt collector now has to actually prove their case, and that, my friend, is where their problems begin. Junk debt buyers, companies that purchase old debts in bulk for pennies on the dollar, often buy thousands of accounts at a time. They frequently lack the original contracts, complete account histories, or proper chain of ownership documentation. The moment you answer, they have to start producing evidence. And a lot of them can't. Even if the debt is legitimate, filing an answer opens the door to negotiation. Debt collectors would rather settle for 40-60 cents on the dollar than drag a case through court. But they only settle with people who show up. Quick pause right here. If this is already clicking for you and you want to take action right now, I've put a link in the description below. There's a tool that will help you draft, review, and file your answer without needing a lawyer. More on that in a minute. Keep watching. How to write your answer. Let's talk about what actually goes into an answer and what should absolutely never go in one. When you get served, you receive 2 documents, a summons and a complaint. The summons is critical. It tells you how many days you have to respond. This varies by state, but it's typically between 20 and 30 days from the date you were served. Miss that window, and default judgment is back on the table. The complaint is a numbered list of allegations. Things like defendant opened a credit account. Defendant owes $X. The account was assigned to the plaintiff. Each numbered paragraph requires a response from you. Here's how you respond to each one. You have 3 options. Admit. If you know something is true, you say so. If you opened a credit card with a specific bank, admit it. Honesty matters here. Deny. If something is false or you have reason to dispute it, deny it directly. Lack sufficient information to admit or deny. This is a legally recognized response, and it counts as a denial. If a debt buyer claims they purchased your account from a chain of 3 companies and you have no way to verify that, you can truthfully say you lack sufficient information. Here's the critical mistake most people make when writing their own answer. They turn it into a story. They start explaining their financial hardship. They offer to settle for half the amount. They describe why they fell behind on payments. None of this belongs in your answer. The court doesn't want your story at the answer stage. It just wants to know, do you admit or deny? Save your story. Save your settlement talk. That comes later in the process. For now, your answer is a clean legal document that says, I am here, and I contest this case. Your answer should also include the case number from the summons, so the court can match it to the correct file, your contact information, and a dated signature. Once it's written, you need to file the original with the court. Most courts charge a small filing fee and send a copy by mail to the attorney listed on the complaint. Keep a stamped copy for yourself. The clock is ticking. I want to pause here and be direct with you. Time is the most dangerous factor in this entire process. Deadlines in legal cases are not flexible. A judge will not extend your response window because you were scared, because you didn't understand the paperwork, or because you meant to handle it. The deadline passes, default judgment gets entered, and the damage is done. So if those papers are sitting on your kitchen counter right now, or in a drawer you've been avoiding, today is the day to act, not tomorrow. Here's the good news. You don't have to figure this out alone. There are services specifically designed for exactly this situation. Tools that walk you through every paragraph of the complaint, help you choose the correct legal response for each one, draft your answer in proper legal format, and actually file it with the court on your behalf. Some even include an attorney review, so a real lawyer confirms your answer is accurate and complete before it's submitted. The link in the description below will take you directly to one of these resources. If you're sitting on a debt lawsuit right now, I want you to click that link as soon as this video ends. The filing fee is real, the deadline is real, and the protection is real. Let me leave you with this. The debt collection industry files millions of lawsuits every single year. Their entire business model is built on the assumption that you won't respond. They're counting on your fear. They're counting on your confusion. They're counting on you doing nothing. Your answer one document filed on time breaks that equation entirely. You don't need to be a lawyer. You don't need to have a perfect defense ready on day one. You just need to show up, because showing up changes everything. If this video helped you, drop a comment below. I read every single one. Share this with anyone you know who has been served with a debt collection lawsuit. And subscribe if you want more practical, no-nonsense guidance on dealing with serious debt situations. You've got this. I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help.